California has just passed a new law that takes direct aim at one of the most popular handguns in America, and it's setting the stage for a massive legal showdown. So today we're going to break down exactly how this law works and why it's on a direct collision course with the Supreme Court.
It's a really good question, right? How can you just ban something so common? Well, the state isn't banning Glocks by name. Instead, they're using let's call it a very clever legal reclassification to get it done.
So here it is. This is the law at the very center of all of this, signed by Governor Gavin Newsom. And like I said, it doesn't mention Glocks by name. What it does is introduce a brand new and very, very specific category of firearm into California law.
And this, right here, is the key. The law specifically targets pistols that have a particular internal part, this cruciform trigger bar. From the state's point of view, this specific design makes the weapon uniquely easy to modify with an illegal device, one that makes it fire automatically. So they're not banning the gun, they're redefining it as machine gun convertible.
The practical effect of all this? It's a sales ban. Now, they're not confiscating existing Glocks, but it effectively puts a full stop on any new ones being sold legally in the state. And that kicks in on July 1st, 2026. Now, this is where it gets really fascinating. There's a huge legal contradiction here. The very devices that make a Glock convertible, these little switches, are already banned nationwide. They've been illegal since 1986. So California is now banning the gun itself because of its potential to be used with another already illegal device. Okay, so this new state law, it doesn't exist in a vacuum. Not at all. It runs smack into two landmark Supreme Court decisions that have completely reshaped the landscape of Second Amendment law in this century. These are the two heavyweights. Heller, which basically said yes, individuals have a right to own a gun, and Bruen, which came along much more recently and created a way tougher standard for any government trying to restrict that right. Let's break them down. All right, so let's dive into the first major obstacle for California's new law, this big decision from 2008, D.C. versus Heller.
This sentence right here is the heart of the matter. The Supreme Court was crystal clear. You cannot just ban an entire class of weapons that are commonly used by regular, law-abiding people for self-defense.
So the huge takeaways from Heller are that this right belongs to you as an individual, and it's at its absolute strongest when we're talking about popular firearms. And its core purpose? Self-defense. You can already see how this sets up a big challenge for a law that targets one of the most popular guns in the world.
Now, let's fast forward to 2022 and talk about Bruen. This case was a big deal because it didn't just reaffirm Heller, it actually created an even higher bar for any new gun restrictions. Justice Thomas, writing for the majority, basically laid down a whole new rule. He said it's no longer enough for a government to argue that a gun law is a good idea for public safety. Now they have to prove it actually has roots in American history.
And this is what everyone now calls the history test. It means for California's Glock ban to stand, the state has to find a similar type of gun regulation from way back in the late 1700s. And, well, that is a very tall order.
So we have these big legal ideas, right? But how do they apply directly to the Glock ban? This is where the abstract legal theory crashes into a very real and a very, very popular handgun.
I mean, just look at that number. Over 20 million produced. By any definition, the Glock is a firearm in common use. That number alone makes an incredibly powerful argument against the ban, just based on the Heller standard we talked about.
And you know, its common use isn't just among civilians. It's the professional standard. Roughly 2/3 of all police departments in the US issue Glocks to their officers. It's the trusted tool for law enforcement all across the country. And to really drive home just how mainstream this firearm is, here's Vice President Kamala Harris, a prominent Californian herself, on the record stating that she owns a Glock for personal protection. It's pretty tough to argue a weapon isn't in common use when it's owned by people all across the political spectrum.
Okay, so this is a really common counter-argument, and maybe you're thinking it too. How can a modern firearm, invented in the 1980s, be protected by a historical right from the 1700s, while the Supreme Court has actually already addressed this kind of thinking? Now, in this case, Justice Thomas was talking about the AR-15, another modern firearm. And he argued that what really matters isn't when the gun was invented, but whether it is currently in common use for lawful purposes. That same logic would almost certainly be applied to the Glock.
So let's put all these pieces together. Let's see exactly how a legal challenge against this California law would be structured.
The legal argument against the law follows a pretty clear, logical path. Step 1. Heller protects firearms in common use. Step 2. Glocks are, without a doubt, in common use. Then, Step 3. Bruin demands that any ban has to have historical precedent. This puts the burden of proof squarely on the state of California to find a comparable law from centuries ago.
So, what happens now? Well, the law is officially on the books, but trust me, this fight is just getting started.
We are looking at a classic standoff. You've got a state's legislative power on one side and the constitutional framework laid down by the Supreme Court on the other. Lawsuits are pretty much guaranteed the second this ban is set to take effect.
And at the end of the day, that's what the courts are going to have to decide. Is this a reasonable attempt to regulate a specific weapon feature they see as dangerous, or is it an unconstitutional ban on a firearm in common use, one that just flies in the face of established precedent? The answer to that question is going to have huge implications for gun laws all across the country.